Good morning, everyone. Happy Monday. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. First thing I want to talk to you about is administrative processing. Some of you know what that means because you've been involved in administrative processing. Some of you don't. If you don't and you've never been involved in it, my hope for you is that you never have to deal with administrative processing. That said, administrative processing is a process by which, when you have applied for a visa overseas at a U.S. consulate, it looks as though the consulate has denied the application, but they have denied it based on administrative processing. So think of it as not really a denial, but sort of an on hold. Administrative processing is where they need to do more investigation about your application. So there's no set time frame for which they need to complete this administrative processing or this extra digging, extra research with respect to your application. It could be a very short period of time. It could be a very long period of time, unfortunately. From my experience with administrative processing, they don't tell you the reason why your application is in administrative processing. Some things that we have seen perhaps that they may have security concerns. A name could have been misspelled either on your application or somewhere in some law enforcement database, which maybe pings your name when it shouldn't be pinging your name. So some of these things are just internal things that the agency has to figure out, deal with, and rectify to their satisfaction before they issue your application. Usually, from my experience, it's a short amount of time. That is not always the case, though. Sometimes it can be a long time. So if you feel like you've been stuck in administrative processing for a long time, reach out to an immigration lawyer, and we can start sort of knocking on some doors and seeing what we can see if we can shake your case loose. But administrative processing does not always mean a bad thing. It does not always mean that it will lead to sort of an actual denial. So that's administrative processing. I wanted to talk about that with y'all this morning. The next thing that we are seeing is termination of parole. So individuals that came in under the CHNV process who are paroled in, we are seeing some of those paroles. They are getting emails saying that that their parole has been now denied or terminated, what have you. But it's a little confusing. Well, really, it's a lot confusing because we've also seen these same emails go to U.S. citizens. Sometimes they've gone to attorneys. They haven't had clients' names attached to the emails. So it's a bit of a sticky wicket at this point. Not quite sure what's happening. Some of the entries, some of the folks that came in under parole, it appears came in under the CBP-1. Others did not. So we're just sort of trying to figure out what's happening here. But if you did get one of those emails, reach out to an immigration attorney and have that conversation so that we can help you sort through this incredibly confusing time. Next thing I want to talk to you about is we have seen we've seen articles, I'm sure you've seen them as well. The one that I will specifically refer to came out of the Miami Herald recently, that a federal judge, based on a lawsuit that was filed, has stopped the Trump administration from ending the parole program that was specific to Cuba, Haiti, Nicaragua, and Venezuela. So a few things about that. The Trump administration wanted to end that program and end everyone's status, terminate everyone's status as of April 24th. The federal court decision essentially said that that cannot happen. So your original end date to your parole documents is when that parole terminates, right? However, the end of the program has already been announced. So the program itself will not be extended. So when your 2 years is over, your 2 years is over. So now is the time. I would say now is past time, but certainly now is the time. If you haven't thought about or haven't spoken with an attorney to chat with them about what your other options are beyond the end of this 2-year parole, now is the time to do that. If you are currently employed, have that conversation with your employer. You and your employer can both reach out to an attorney. You can reach out to my office, but have that conversation so that you are not at the very, last day or last week or last month of your parole time, then starting to figure it out. You want to figure this out now. So that is what we are seeing out of federal court in one instance. Travel is still really squishy. That is my very legal word. Those of you that work with me know I use very legal words like squishy. So travel is still pretty squishy. I am recommending to my clients, some of them after extensive conversations, to avoid traveling outside of the US if at all possible. Although I think legally most of my clients would be okay with travel, meaning they have the right documents, everything's in place. They may or may not have traveled before in and out of the US without any problems. I still think travel is a little bit squishy right now. And so I generally tend to take a very conservative approach on these types of things. We are seeing a lot more scrutiny with people coming into the border, coming in through our airports, through our land borders. So if you are an individual that has lawful permanent residence or a green card, we use those phrases interchangeably, and you have a criminal history, whether it was a criminal history before you got your green card or after you got your green card, I definitely at this point would not recommend that you travel. If you know that you were not so forthcoming and not so honest on any of your prior applications before receiving your green card, the Immigration Service might catch on to that, right? And so meeting them at the border may not be the best solution for you. And if you are someone that at any point while having your green card stayed outside of the US for more than 6 months, you too could have issues when you try to come back in. So if you fall in sort of one of those 3 broad categories, I wouldn't recommend that you travel. I think travel is just beyond squishy, and I think it needs to be something that you take pretty seriously at this time. That said, if you have no choice and you have to travel, and you fall into one of these sort of 3 categories, have a conversation with an immigration attorney, and so that you know what your potential consequences are if you travel. Okay. Next thing I want to talk about are what do you do with your documents when you travel? What happens if you lose documents when you travel? What happens if you are pickpocketed or your documents were stolen? What happens? So you're always going to want to try to get, in order, if you're outside of the US and you need to come back in and someone takes your passport, they take your visa, what have you, you're going to need to get those documents replaced. It is always easier to replace those documents if you give the consulate something to start with. And by something to start with, I mean a copy of those documents. So I always tell people it is extremely important to have a copy of the biographic page of your passport, all the current visas in your passport, even if they're not for the United States. If they're valid, you want to keep a copy of those as well. Any visas that you have to get you into other countries, you want copies of those. If you are in the US or if you have a social security number and a card, you want to get a copy of those. If you have a driver's license, you want to have a copy of that. You also want to have a copy of your birth certificate and any marriage certificates. And so you may say, well, Carol, what am I supposed to do with all these copies, right? I always recommend you have at least one hard copy. I know paper, it's a novel concept these days, but paper, leave that with a trusted friend or a family member. And then always have a digital copy that you can access when you're outside of the country. So in case you lose your documents, in case your documents are stolen, right? In case you get stopped at the border, somebody has a copy of those documents and can start, it is a good starting place to have a copy of those documents. So just keep that in mind. I tell that to all of my friends, my clients. It is always easier to replace documents if we can give the government copies. We can show the government copies. I have had a question last week, and so I wanted to and it was a good question, so I wanted to talk to y'all about it this morning. And it is when we file for U.S. citizenship. It's a naturalization application. That includes an English test. So people have asked, well, what's on the English test? What does that mean? Wait, I didn't know about that. So I'm going to tell you. So the English test is not as intimidating, I think, as any of my past clients have sort of made it out in their minds before we've had a conversation about it. The English test is 3 parts. It's reading English, speaking English, and writing English. So for the writing of English, the officer will speak and read to you certain sentences, and you have to write them. So you have to get 1 out of 3 of those sentences correct to determine your ability to speak English. In terms of speaking English, as the interview is done, because it is conducted in English, the officer will determine whether or not you are understanding what's being said, right? So if the officer, tells you, hey, we're going to start the writing portion, and you sit back and don't pick up a pen, then maybe you're not quite understanding, right? So the officer will determine your ability to speak and sort of understand English based on the normal course of the application. The officer will also give you sentences to read aloud. You need to get 1 out of 3 of those sentences correct in order to demonstrate your ability to speak English. So it's not as sort of horrible as some of my clients have thought it was. I think people think it's going to be, sort of like an elementary school sort of classroom setting, and it's not. It's all done in the officer's office. So that's the English test for naturalization. I want to end this morning with extraordinary ability, green card, the EB-1A category. We know it's a first preference category. It really shows that you are at the top of your field. So another really legal phrase I use is, I tell people, we need to show that you're the best thing since sliced bread. I use very legal terms. I use words like squishy and phrases like the best thing since sliced bread. So there is no one size fits all for this particular category. There is no one industry. There is no one type of field that makes the EB-1A extraordinary ability green card better than others. Any profession can qualify as long as you provide documents and show that you meet the criteria. So I have a lot of people saying to me, well, I'm in the STEM field, so I definitely want to do EB-1A. Okay, you're in the STEM field, and that's great. What is it about the STEM field? What is it that you're doing in your particular field that puts you at the top of your field? What is it that has your colleagues respect in terms of what you're doing and what you've achieved in the past and where you want to take this in the future? So for EB-1A green cards, it's not just STEM. It's not just one specific industry. It's not just one specific job path. So just keep that in mind. It's all about the documents that we can show that you meet the criteria. So that's what I have for y'all this wonderful Monday morning. If you have any questions about your case, have any questions about some of the legal lawsuits that have been popping up, if you're looking to travel, you're not quite sure how to do that, feel free to give our office a call. We're happy to help. Have a wonderful Monday morning and a great rest of your week.